London Borough of Bromley.
Yes, thank you. Mr. Burton. Yes.
My Lords, my Lady, two brief matters arising from the submissions yesterday, if I may first. Just in relation to ground 2, the public sector equality duty, obviously my submissions yesterday were focused on criticising the judge's characterisation of the equality impact assessment, and why we say that mischaracterisation led to him falling into error when dismissing that ground of challenge. I should have perhaps pointed out at the time, however, that we did say below that the local authority was in breach of the PACD for precisely the same point that I outlined to you yesterday, namely the issue concerning specialist services. And I wanted just to give you the reference for that in the skeleton argument below. It might be useful for you to look at that later. So if I could just invite you to turn up the skeleton below at core bundle, page 139. Uh, 138, I apologise. You'll see there under the heading of breach of PSED, beginning on paragraph 47, the principles are set out, including those taken from the well-known case of Bracking at paragraph 49. And of particular relevance were the principles at B and C, B being the citation that in order to discharge the duty, the decision maker must be clear precisely what the equality implications are that he puts then in the balance. And then C, the duty of non-delegation, the one I emphasised yesterday, which is reiterated again at paragraph 50. But then the critical point that we were looking at yesterday about specialist services is made at paragraph 52. Which is essentially the point that the executive was not told about the fact that specialist services would have to be at Kentwood, thereby undermining the mitigation based on the utilisation of spokes around the hub.
Thank you.
The second point arising from the submissions yesterday concerns ground 3 on costs.
Yes.
My Lord Justice Dingemans just asked me a question about, well, what's our position if the judge did indeed apply the wrong test? And rather than make those submissions orally today, what the parties did last night is provide you with the written submissions on costs that were provided to the judge below. And they obviously deal with both the question of what the test should be and then what the parties said respectively about what should happen if the test was applied in that way. The claimant claiming his costs based on the fact that the principal finding of unlawfulness had been made, the local authority claiming its costs based on the premise that nothing tangible came out of the proceedings. For current purposes, I simply say on behalf of the appellant that we would repeat those submissions, but we would say the outcome would be different if one applied the proper test as set out in Hunt and Rakib. It would be a matter for this court to then reach a substantive decision on that should you be with me on the incorrect application of the test, and if costs become a live issue in that way. And my lady, my lords, that leaves 3 issues for the appellant to cover this morning.
Yes.
The duty to consult, the ancillary issue of prejudice, and then the issue of delay.
Yeah.
I will be taking the submissions on the first of those 2 points. My learned friend, Miss Irving, will be taking the submissions on the third of those on delay.
Good.
I've covered with my learned friend that if we were at a maximum an hour and a quarter this morning, would that leave him sufficient time to deal with his submissions? And he said yes. Leaving a short opportunity for reply for me later on this afternoon. I'll try and do it in less. And the reason why it might take a little while to deal with the first of those is the local authority's case on consultation has, if I may respectfully say so, shifted on the appeal from the one that they advanced below. And it does involve some consideration of authority, which we're going to have to look at some point anyway. So that would be my proposal. So coming on to that issue of the duty to consult, how I was planning to take you through it was to look and summarise very briefly how the case was put below, then summarise briefly how the judge dealt with those submissions below, before coming on to how the local authority now puts its case in this court, happily we can stay in the skeleton arguments in the core bundle for the purpose of summarising the case as it was put below on this point. And now looking at paragraph 34 of the appellant skeleton below, page 133 in the core bundle.
Yes.
Now, because I'm going to take you to these authorities briefly in due course, I'm just flagging what was essentially said at this stage. The first is that my learned friend took the court to the Supreme Court case of Mosley, where reference is made to the duty to consult based on legitimate expectation in particular, with specific reference to a case called R versus Devon County Council ex parte Baker,
Yes.
which dealt with the situation where there had been no prior practice nor promise to consult, but nevertheless the courts recognised that the relevant person had an interest in the subject matter that was proposed to be changed such that the law would recognise a duty to consult. Building on that was the judgment of Lord Justice Laws mentioned in the following paragraph, paragraph 35. Again, I'll come back to the detail of this in a little bit, but the essence of this was a recognition, again by Lord Justice Laws, building on the Baker case, that there could indeed be a circumstance where the law would recognise, as part of the duty of fairness and legitimate expectation, a duty to consult in circumstances where the past conduct of the public authority on the affected persons was pressing and focused. And as the learned judge, Lord Justice Laws, said, one would expect at least to find an individual or group who in reason have substantial grounds to expect that the substance of the relevant policy will continue to endure for their particular benefit. So that's the Bat-Murphy case. But then the submission is clear that what fairness requires, paragraph 36, is fact sensitive, the categories of unfairness are not closed, and precedent should act as a guide, not a cage, again citing Bat-Murphy. Then specific reference is made to two cases which were said by the appellant to be of assistance to the court in determining the question in this case. They are indeed ex parte Baker, which concerned a closure of residential care homes, and then the case of LH versus Shropshire, again a decision of the Court of Appeal, which by analogy with Baker said that the principles in Baker would apply equally well to daycare centres.
Sorry to interrupt, not that it matters particularly. You say appellant, is this the appellant skeleton below?
My lord, yes.
Yeah.
Apologies if I wasn't clear about that.
No, but it's fine, it doesn't really matter, we're just looking at the law, but I just wondered whose it was.
We are at this stage, that's right, but we're
Yes,
just about...
I got the local authority. This is your skeleton.
This is our skeleton, I do apologise.
Yes.
No, don't worry, you did go right and say that it was appellant, but you had, I think, earlier...
Well, I'm very sorry if I said that. That would be manifestly, diametrically wrong.
But this is your submission.
This is our submissions, and the essence of what I'm at the moment characterising is how the case was put below. Recognition that there's not, that in certain circumstances, as recognised by the highest courts, there will be, or may be, a duty to consult in certain circumstances where a benefit is deprived and where fairness otherwise requires it, building on those cases. And then at paragraph 37, building again on Baker and LH, the submission was made on behalf of the appellant below that a proper analogy could be drawn between how the LDD learners engage with the Poverest Centre, albeit a centre of adult education, and the cases of Baker and LH, which concern residential homes and daycare centres, respectively. And the reason for that was based on some of the points that were made in paragraphs 37 and 38. Essentially that it was a relatively small identifiable cohort, they'd been enjoying it for decades, that the proposal now was to deprive them of that benefit without any prior notice or consultation. At paragraph 38, the claimant's unchallenged evidence that the closure of the Poverest Centre is very serious from the perspective of the LDD learners and those who care for them, and further indications to why that was so.
In your text, you've got Longmore, Mr. Justice Longmore. I think he was Lord Justice Longmore.
Was Lord Justice Longmore.
Yeah.
Apologies if the skeleton below.
No, don't worry. It's just trying to get it right. And who gave the judgment in Baker? That was Lord Justice Simon Brown.
Simon Brown, yes.
Yeah, thank you.
And I'm going to come to those in due course. But the essence of the case put below was to say fairness may require in certain circumstances. The circumstances have been set out in Baker and Murphy, and then Baker was applied by analogy in another Court of Appeal case, LH, and this case is very similar to LH and Baker, and therefore the same outcome should result. Again, I'm summarising, but then looking at the defendant's skeleton below, we see consultation dealt with at page 152 of the bundle, paragraph 36 onwards. The entirely uncontentious point is made at paragraph 36, certainly uncontentious below, that there is no general common law duty to consult persons who may be affected by a measure. And of course that's true, but citing the Baypal case. And then down at paragraph 42, that you must establish substantial prejudice in order to demonstrate a breach of a breach of procedural fairness, a point picked up by my learned friend's second round around prejudice. And then in terms of the core submission, that's at paragraph 57, where my learned friend maintained that there was no proper analogy to be drawn between the facts in LH and Baker and the facts in the present case. So moving then next to how the judge dealt with these issues, if I may. The judge set out the relevant legal principles at paragraph...
So, to the judgment, yes?
Judgment, yes please. Beginning at paragraph 39. Mm-hmm. The public body's duty to consult before taking the decision is simply part of its duty to act fairly. The approach is governed by whether someone has a sufficient interest so that there is a legitimate expectation of such consultation, citing Mosley in particular, which in turn cited Baker. Citing also another passage from the judgment of Lord Wilson in Mosley, about what the purpose and the reason why the courts find a duty to consult in such cases. I'll take you to that paragraph in the report itself in due course. Then at paragraph 40, the judge identified the touchstone emerging from Lord Diplock's speech in CCSU, about whether a claimant has in the past been permitted to enjoy some benefit or advantage, whether or not he or she can then legitimately expect procedural fairness, and if so, to what extent will depend upon the court's view of what fairness demands in all the circumstances. Which is also almost word for word Simon Brown, Lord Justice Simon Brown's judgment in Baker. And then referencing LH and Shropshire.
Well, he accepts your or observing's submission.
Indeed, he does.
On the analogy.
Yeah, there he's drawing out why they should be, the principles should be applied, but then we actually see the application of exactly that, my lord, from paragraphs 49 onwards, where he actually deals with this case.
Yeah.
Just highlighting some of the key points, that the claimant and other users have used the Poverest Centre for many years, that the change is significant for those with a learning disability in particular. There is no significant distinction between day centres and adult education, as users of both have a legitimate expectation they will continue to serve the community in their different ways and meet the social needs of learners who attend. Reference is specifically made to the fact that the claimant's social care assessment identifies his need to develop and maintain social relationships or personal relationships, and that indeed is done at the Poverest Centre in recognition of the overlap between the provision of adult education and social opportunities. The approach in Baker and LH applies here. Goes on to acknowledge the fact that this was part of a broader set of decisions, and that the decision was highly fact and context specific, and indeed the local authority take an expert advice. As the judge found, however, that does not displace the need to consult in an appropriate case. This is a local provision of a benefit to an identifiable cohort, both users of Poverest and those with special needs to take courses suitable for people with learning disabilities. It is not a politically delicate national decision or national policy. We'll see that both of those statements echo some of the statements in the leading cases that we'll look at in a moment, so the judge has those well in mind. And then on the point of the fact that the local authority is still to consult on the operational plans for the hub and spoke model, he again acknowledges that. And acknowledges there may be meaningful consultation in relation to that because they're still at a formative stage, but then says, however, it's too late to consult over the provision of the specialist courses at Poverest, as the decision has already been taken to locate them at Kentwood. Then at paragraph 54, the judge recognises that this was all part of a wider review about the property portfolio, and he accepted that consultation was not required of the users of every property included in that review. However, once Poverest was identified during that review as a centre proposed for closure, long-term users of this adult education centre had a legitimate expectation to consultation, in the same way that a local authority should consult residents of an old people's home or users of a care centre, should be daycare centre, which they proposed to close. The fact that some courses would be provided elsewhere does not remove the legitimate expectation that specialist Poverest courses would continue to be reasonably available to them. And then finally, dealing with the question of prejudice, we deal with this now. Fairness required that the defendant consult with learners and their family carers before deciding to close Poverest, and the claimant was prejudiced by that failure to consult. He and others were denied the opportunity to be heard. They had something to say that was relevant to the decision to be taken. They would have commented on whether the need for specialist courses in the south of the borough was so important that it outweighed the factors in favour of closure. And then he goes on to allude to the factors below, which of course is section 31. So that's how the judge dealt with the submissions that were made before him below. So in very brief terms, if I may, what is now being alleged by the local authority, just so we're clear about those before we look at the cases. If I could invite the court to turn up the respondent skeleton argument. Again, I'm headlining this for current purposes, so I understand what the case is against.
So I'm on page 54, is that the right place? Paragraph 31?
Yes. Paragraph 31 is where the local authorities start to cite the law, and in particular they cite the case of Plantagenet, which is a case that we'll come on to in due course. But what that all leads to, if I may summarise it quickly, is paragraph 43. So this is the first time we see an allegation of error by the judge below, is why I'm taking you to it. The judge fell into error in his approach to the existence of a duty to consult. There is no reference to the judge's analysis, to the exceptional nature of the obligation to consult in these circumstances, citing back Murphy and Plantagenet.
Was Plantagenet cited below?
No. Nor is there reference to the related requirement for there to be a conspicuous unfairness in a failure to consult. That in the respondent's submission is an error of law. The skeleton then goes on to deal with LH and Baker, and at paragraph 46, this court is being invited to depart from the decision in LH, a decision of the Court of Appeal. And then finally at paragraph 48, it said that in any event LH and Baker were distinguishable, a repeat of the point that was made below.
What are our powers to depart from decisions?
We deal with those in our supplementary skeleton, my lord.
Yep.
And you will find that at paragraph, I'm going to take you there in due course in any event, but it's paragraph 10 G4, hopefully, which is at page 8 of my copy of the skeleton. Let me get it for you. The supplementary skeleton, I think, actually never finds its way into the bundle, of course. I'm hoping you have that.
Yeah, we've got it loose.
I do apologise.
Yeah.
So if you've got that just as a loose copy, it's then page 8.
Yeah.
At the bottom of that page.
So back to Young and Bristol Aeroplane, etc.
Exactly. We say there's not even a proper contention that we fall within any of those categories in this.
So, just flagging out for our own purposes, when we go through the authorities, we've got to keep an eye out for Mr. Beglin's contention in paragraph 45 that what Lord Justice Longmore said was inconsistent with what Lord Justice Laws had said in Bart Murphy.
I mean, if that's exactly how he puts his case, I mean, my understanding of the case, as I understand it, is that the dicta in Plantagenet about conspicuous unfairness is a new test that should be applied in cases of this kind. And if it is applied, then the cases decided previously, including LH, fall to be decided differently. I mean, I think I'm putting his case at the highest that I can. I mean,
Plantagenet was divisional
court.
I'm doing my best to understand how this argument is being put before us so I can try to address it.
Yes.
In my submission, we don't get anywhere close to that when we look at the authorities, because all that happens in Plantagenet is it's a neat summary of some of the principles coming out of some of the cases. It wasn't said by the divisional court that this was now the test, and the case referred to, which is the decision of the High Court, didn't say this is now the test. So we don't really get to stage one of this argument. Where we are left is we've got a number of Court of Appeal decisions which set out a number of principles, all of which were cited to the judge below, in which he applied his mind to and then applied to the facts of this case. And he did exactly what one would expect a judge to do in these circumstances when one's looking at categories of unfairness in the context of procedural unfairness and legitimate expectation in particular. He developed the position incrementally by analogy with previous cases, which is an approach which is explicitly foreshadowed and endorsed by the Court of Appeal in, amongst other cases, Baker.
Yeah. Right, okay, so that's... is there anything else you want to draw to our attention, Mr. Beglin's skeleton?
No, at this stage, that's my understanding of the case. It's really essentially those 3 points, that the test is now either different or required specific language to be used that wasn't used by this judge. 2, LH shouldn't be followed, and even if they're wrong about that, the analogy the judge drew with LH and Baker was somehow impermissible. We deal with all of those points in our supplementary skeleton. So what I was proposing to do is take you through the cases fairly briefly, and then headline our points in response, but also giving you the relevant paragraph numbers in this supplementary skeleton. So you have those, and I've made those points orally, as it were. My learned friend can then deal with them as he sees fit. And if there's anything left for me to cover in reply, I'll do so then. So, proceeding with that approach then, if I could invite the court to turn up the Supreme Court case of Moseley first, and let's start at the top, as it were, which is behind tab 9, Authorities Bundle, page 202. Now, the significance of this case doesn't lie in its facts, because this was a case about a statutory consultation. Its broader significance is this really is the only time the Supreme Court have said very much about duty of consultation, and they say something particular about one of the cases that is pivotal, or two of the cases one might say that are pivotal here. So if one can begin with paragraph 23 of Lord Wilson's judgment, where he deals with the law, and this is the passage that the learned judge below cited in particular. Where Lord Wilson acknowledged that not infrequently, despite it not being a statutory duty to consult, a duty to consult is generated by the duty cast by the common law upon a public authority to act fairly. The search for the demands of fairness in this context is often illuminated by the doctrine of legitimate expectation. Such was the source, for example, of its duty to consult the residents of a care home for the elderly before deciding whether to close it in ex parte Baker. But irrespective of how the duty to consult has been generated, that same common law duty of procedural fairness will inform the manner in which the consultation should be conducted. We're not so concerned with that second category question. Paragraph 24, fairness is a protein concept not susceptible of much generalised enlargement, but its requirements in this context must be linked to the purpose of consultation. In Osborne, the court addressed the common law duty of procedural fairness in the determination of a person's legal rights. Nevertheless, the first two of the purposes of procedural fairness in that somewhat different context, identified by Lord Reed of his judgment in paragraph 68 of his judgment, equally underlie the requirement that a consultation should be fair. First, the requirement is liable to result in better decisions by ensuring that the decision maker receives all relevant information and that it is properly tested. And second, it avoids the sense of injustice which the person who is the subject of the decision will otherwise feel. So part of how the duty of fairness plays out in the context of legitimate expectation is to reinforce both of those principles.
Yeah, although you have to be careful to distinguish between what's desirable for a decision maker, which is for the decision maker, and what's unlawful.
Absolutely. Fully accept that. But why those are...
Can I, Mr. Burton, there has been some case law development, hasn't there, on fairness in the context of legitimate expectation. I'm thinking about cases like Gallagher, where the Supreme Court stepped back a bit. I think that's to do with substantive legitimate expectation, is it? So are we, just really to say, are we seeing a sort of slight division?
It's a very fair question, my lady. So Gallagher is a case, yes, in a different context, but actually I'm going to make one reference to Gallagher because it's picked up in the freedom from torture case that we passed up the other day. And there is a sort of ironic, I mean, I'm just going to flag this now because it is ironic in the context of this case. The conspicuous unfairness test has spun off now into this other satellite question of maybe you don't even need legitimate expectation to establish a conspicuous unfairness basis for there to be a duty to consult, which is to build out, as it were, sideways from the case law that led to or was established up to that point. But we don't need to concern ourselves with that, because nobody here is arguing we're outside the parameters of legitimate expectation. We're either in it or we're not. But what was dealt with Gallagher in a number of other cases is ambitious advocates saying, well, maybe we can just take this banner of conspicuous unfairness and...
You say it's all very unfair and
yes,
not have to have any other...
Exactly, my lady.
But my sense is that the senior courts have rather stepped back from that and said, no, it's sort of, you've got to show irrationality of decision making, and conspicuous unfairness can't be
they have, absolutely.
On its own.
Yeah.
But I'm very reassured if you say we don't really need to go.
We don't need to go anywhere near it.
That's all a different bucket that we're in, and that we can safely stay on the idea of legitimate expectation as a sort of concept of general fairness as to when procedurally you have rights to be consulted.
That's exactly right.
On reasonable ground there.
That's exactly right. There is no independent ground of challenge called conspicuous unfairness, despite various others' attempts to build one out of the Plantagenet dicta. I'm going to say something about that because I think it's important as to where it came from, but nothing more than that.
I'd be very assisted by that because I'm interested in it.
No, I'm most grateful, my lady. So that's Lord Wilson, I apologise, in Moseley. Just quickly then looking at Lord Reed in Moseley, paragraph 35, which we see at 216. It's again bringing in the notion of procedural fairness. This is an important paragraph which we say, as it were, provides the parameters of this case generally and others like it. So procedural fairness, as Lord Wilson said, protein concept, wide-ranging, There is, however, no general common law duty to consult persons who may be affected by a measure before it is adopted. And again, as I say, that's uncontroversial and accepted by the appellant below and here. The reasons for the absence of such a general duty were set out by Lord Justice Setley in Bappel, and we'll have a quick look at Bappel in due course. A duty of consultation will, however, exist in circumstances where there is a legitimate expectation of such consultation, usually arising from an interest which is held to be sufficient to found such an expectation, or from some promise or practice of consultation. So again, we're in the former of those three scenarios in this case. The general approach of the common law is illustrated by the cases of, again, ex parte Baker, which is in the former of those, and Coughlin, cited by Lord Justice Wilson, with which Lord Wilson, I said it again, I do apologise, with which the Bappel case might be contrasted.
This is where I get confused, and you may not have to solve my confusion, but Coughlin was a substantive legitimate expectation case, wasn't it? That was about whether you could actually stay in the care home, which
Absolutely.
was meant to be
That's exactly right.
closed, rather than whether you should be asked to.
Yes, there's been an unequivocal promise you get to stay here for life.
Yeah.
Untying some of these knots is done a little bit by Lord Justice Laws in the Back-Murphy case, which we'll come on to.
Yep.
I mean, and again, of course, this is the Supreme Court simply summarising the position about fairness, and we accept that. But it goes back to some of the observations I was making yesterday in response to my Lord Justice Dingemans' questions about how consultation might look in this context. If I could just invite the Court just to scroll down while we're here at paragraph 37. Depending on the circumstances, issues of fairness may be relevant to the explication of a duty to consult. The present case is not, in my opinion, concerned with circumstances which a duty of fairness is owed, and the problem with the consultation is not that it was unfair, as that term is normally used in administrative law, and he goes on to explain that this was about a statutory duty to consult. And then at paragraph 38, such wide-ranging consultation in respect of the exercise of a local authority's exercise of a general power in relation to finance is far removed in context and scope from the situations in which the common law has recognised a duty of procedural fairness. And there is something in the authorities that one will pick up, and it's a theme going through them in my submission, that where you are looking at decisions made of a, as it were, strategic, macro-political or national policy level, you're unlikely to be in the territory of procedural unfairness, which tends to be focused on smaller groups who've had some form of benefit for a long period of time, which is proposed to be taken away from them without consultation. And the language, just to get ahead of myself a little bit, that Lord Justice Laws uses to describe, in my submission, that type of scenario, is a pressing and focused form of context. Not the kind of context which one saw, albeit in a statutory context in this case, or as I'll come on to show you, in Bappel or in Back-Murphy, which concerned national policy measures affecting many, many people, and had a very different feel from the pressing and focused nature of the cases where duty has been found, which is LH and Baker, and we say this case. So that's dealing with Mosley for now. So if we could then turn up the decision of Baker, which is endorsed in Mosley in that way, which is behind tab 3, beginning at page 57 of the authorities bundle. You see there in the report, which I'm not going to take you to just now, I'm going to take you to the judgment, and that begins at page 61. And at this point we're in the judgment of Lord Justice Dillon, which I'm not going to deal with substantively, but just to cover off a couple of points.
Sorry, I was just making a note. Can you just give me the page reference?
So we're now in Baker, which is tab 3, my lord, and I'm currently at page 61 in the authorities bundle, where the judgment of Lord Justice Dillon commences.
Thank you.
So this was 2 appeals that came before the Court of Appeal, both concerning the closure of residential care homes used by the elderly. And 2 points were raised, one about consultation, one about alternative remedy. We're not concerned with the second. But under heading 1, letter E, Lord Justice Dillon records that it is said for the applicants that each county council owed a duty in law before resolving to close a residential home to consult the permanent residents in that home over the closure of the home, and not merely over what was to happen to the residents after the home was closed. It is said that what consultation should amount to was a matter of some flexibility and not governed by strict rules, and to that I return below. It was accepted by the councils that they owed the residents a duty to act fairly in making the decision to close a home, and it was submitted for the applicants that the duty to consult was an aspect of the duty to act fairly. So, all well and good so far. It was further urged to the applicants in the Devon case, there are two cases as I said, that specific promises of consultation had been given by a member of the respective local authority. And again, the judge indicates he will return to that. Just before I come to the judgment of Lord Justice Simon Brown, just to demonstrate how Lord Justice Dillon disposed of those cases, if we turn to page 67, no, sorry, could I invite the court just to turn up to 66. This is just so you have some of the key facts in mind. Sorry, page 66. So in the Devon case, where there was said to have been an express promise to consult, what ultimately the court found was that promise was maintained, consultation was given about the specific closure, or the closure of the specific residential care home. And we see the facts that give rise to that finding, beginning at that is not, however, the end of the aspect of the Devon case, which is the second paragraph. And in effect, what happened is that the residents were given 2 weeks to respond to a proposal to close their residential care home and an opportunity to comment. And then coming down to the passage on the following page, which is page 67, next to letters E and F, the paragraph beginning as to that, Lord Justice Dillon goes on to say effectively, well, the requirements of consultation as they were understood then were met. They had ample opportunity to engage themselves at various meetings and such like. That contrasted sharply with the Durham case, which is at the bottom of page 67. There was no prior indication that there would be consultation. The decision to close the particular care homes was made on the 15th of January 1992. Turning over the page to 68. Second paragraph. Nothing was done, however, about consultation with the residents over the closure of the homes before 15th of January 1992, except that on the previous Friday, 10th of January, letters were sent by hand to each home, which was to be closed by the Director of Social Services. Substance of the letter was as follows, etc., etc. And then final paragraph at the bottom, the impression I get from the papers is that by contrast to the residents in the Devon homes, who had a long notice of what was being considered, the residents in Ridgeway House were helpless when told at virtually the 11th hour the closure of Ridgeway House was on the agenda for the meeting on the 15th of January. So notice was insufficient. Of course, this is a case where there was no notice at all. It was a fait accompli by the time the residents were told. But nevertheless, that's a key fact that distinguishes the two cases from the perspective of the Court of Appeal. I'm not then going to trouble you with the rest of Lord Justice Dillon's judgment, because it's not the one then cited by cases thereafter. But suffice to say that effectively Lord Justice Dillon says, in the same way, this was a breach of the principle of procedural unfairness based on legitimate expectation. And we can see that if you wish to read it from page 69 onwards. But it's the judgment of Lord Justice Simon Brown which has been referred to since, because it provides an analytical basis for legitimate expectation in this context. And we see that at page 71. And the first question that's asked of the court, what if any process of consultation with residents is required if a local authority is to act fairly in deciding which of a number of old people's homes are to be closed as part of an overall reorganisation of this facility within the area. Just turning over the page, and the third paragraph beginning, much of the argument before us has focused on legitimate expectation. And then Lord Justice Simon Brown goes on to say what he believes the various categories of legitimate expectation to be. And here, my lady, we start to get into the territory of the distinction between substantive and procedural. The first category identified by Lord Justice Simon Brown is substantive legitimate expectation, based on a clear and unambiguous representation upon which it was reasonable for the person to rely. And then the second category, perhaps more conventionally, the concept of legitimate expectation is used to refer to the claimant's interest in some ultimate benefit which he hopes to retain, or some would argue attain. Here, therefore, it is the interest itself rather than the benefit that is the substance of the expectation. In other words, the expectation arises not because the claimant asserts any specific right to a benefit, but rather because his interest in it is one that the law holds protected by the requirements of procedural fairness. The law recognises that the interest cannot properly be withdrawn or denied without the claimant being given an opportunity to comment, and without the authority communicating rational grounds for any adverse decision. Of the various authorities drawn to our attention, and the learned judge identified Schmidt and Schmidt and Schmidt. And then just at paragraph 4 for completeness, the final category of legitimate expectation encompasses those cases where there is a promise to consult, effectively. So it's different from substantive legitimate expectation in the sense it's not a promise of a benefit enduring indefinitely, but it is an explicit promise to consult. Towards the bottom of that page, insofar as the appellants, the judge recognised that in the Devon case they were relying on category 4, explicit promise to consult. And then over the page is when one turns to the Durham case, the issue of consultation arises in its sharpest form. No promises or practice of consultation here being asserted by the appellants. No actual process of consultation, in fact, afforded by the counsel. The Durham case, in short, on the facts could hardly be more unlike the Devon case. And here he identifies that this is a case falling within his category 2, the one we were looking at a moment ago. And that paragraph in the middle of the page, as stated, the second category of legitimate expectation comprises those interests which the law recognises are of a character which require the protection of procedural fairness. What then is the touchstone by which such interests can be identified? It cannot merely be that the law insists that they be not unfairly denied, else there would be no point in introducing the concept of legitimate expectation in the first place. So no broad category of unfairness, this is about legitimate expectation. Then refers to Lord Diplock's speech in CCSU, and that citation there, which forms the bedrock now of where we end up ultimately in the subsequent cases, including Bat-Murphy. Class B of legitimate expectation arises where, by depriving him of some benefit or advantage which he has in the past been permitted by the decision maker to enjoy, and which he can legitimately expect to be permitted to continue to do so until there has been communicated to him some rational grounds for withdrawing it, on which he has been given an opportunity to comment. And as the judge recognised in the final paragraph, thus the only touchstone of category 2 interest emerging from Lord Diplock's speech is that the claimant has in the past been permitted to enjoy some benefit or advantage. Whether or not he can then legitimately expect procedural fairness, and if so, to what extent, will depend upon the court's view of what fairness demands in all the circumstances. So there isn't even a general duty applicable in circumstances where there has been some past benefit. So it's not even, as we'll come on to see, the submission made in BAPA was that there should be a general duty where anybody's going to be affected by a change in policy. But here we can see that it's not even as broad as saying that the existence of a past benefit is enough. You need to look for something further. And then you see in the following paragraph how Lord Justice Simon Brown understood that to to apply, and effectively says, well, we're starting with the premise that the standards of procedural unfairness will be higher when the authority contemplates depriving someone of an existing benefit or advantage.
Somewhat higher.
Some advantage, yes. And then the learned judge turned to the Durham case. These thoughts of mine are returned to the Durham case. That the appellants have hitherto been enjoying some benefit or advantage of which the County Council now proposes to deprive them cannot be doubted. And the authorities they accordingly get to the first place in terms of asserting a legitimate expectation of some procedural fairness. It is no good pretending that the authorities carry them or the courts a single step further than that. The fact is that it still remains for the court to say, unassisted by authority, save only insofar as there may exist other cases analogous on their facts, whether that legitimate expectation ought to be recognised, and if so, precisely what are the demands of fairness in the way of an opportunity to comment and so forth. And then the learned judge goes on to endorse the fact that in the facts of the Durham case in particular, 5 days' notice of the proposed closure of Ridge Road House gave the residents wholly insufficient opportunity to make such representations as they would have wished to make in favour of their home being kept open in preference to others. I do not say they needed to be consulted individually, nor do I say they needed to be informed of anything like the entirety of the material which would clearly be relevant to the Council's eventual overall decision. It would have been sufficient to consult the body of residents as a whole, notifying them of the need to close a proportion of the Council's care homes and inviting them to indicate what particularly they saw as the merits of their home and what reasons they would wish to advance for its retention in preference to others. So again, we're seeing there, consistent with the observations by Lord Reed in Moseley, that what then is required in terms of the substance of the consultation will reflect the duty of fairness that's been found to establish the right to have a consultation at all.
What do you say about the proposition that, in fact, Lord Justice Simon Brown is not there sort of suggesting a gunning type consultation? If you look, it specifically says they don't need to be consulted individually.
Yes, but if you look down a little bit further, you'll see G, what Lord Justice Simon Brown said about that.
No.
He's not diluting the degree to which the 4 stages of gunning need to be applied, but gunning are set criteria that are always fact-specific, as I said yesterday.
Yeah.
Now, what we don't see in this case is the language of pressing in focus that's picked up subsequently by Lord Justice Laws. But in my submission, everything that's said about this particular case would fall within that notion or that category. You've got a benefit of an intimate kind that's been provided for a long time, which is going to be withdrawn in circumstances where the local authority is proposing a grander reorganisation, but doesn't actually consult with the individuals affected. And all the duty would then entail was affording them a proper opportunity to have their say. And in terms of when one can identify a category of case where the court would similarly find a duty to consult, what we have from Lord Justice Simon Brown is a reference to the suddenness of the decision without any form of consultation in circumstances where they've enjoyed that benefit for some time, and then clearly saying that the way in which this will be developed, or the only way it can really develop, is by way of analogy. So my submission is important. And it's not unfamiliar, of course, to how the law develops in concepts of unfairness. You look for similar scenarios where the court has said the same thing. You said, well, is this scenario analogous to it or not? And that's precisely what the judge did in our case. So dealing then very swiftly with Bapau, which was a very different type of case. Now we're in the context of national policy, which is behind tab 4B, is where we see the judgment, which begins at page 81 of the authorities bundle. Now, the facts of this case are relatively complicated, but you don't need the detail.
Mine 4A or 4B?
4B, my lady, should be the judgment, I believe. 4A is a ACD report, which isn't particularly helpful. So dealing with this as swiftly as I can, the rule changes that were the subject of challenge in this case are detailed at page 83 of the bundle, paragraphs 8, 9, 10 and 11, which I'm going to do my very best to summarise quickly. These are changes to the immigration rules, so the national immigration rules, which affected the circumstances in which people from abroad could come to the UK and access training, medical training, in order to qualify for jobs in the medical professions here. And the principal change was one which said that you could access that training, but only if you were graduates of UK medical schools. That was a significant change. And moreover, for any of those who were currently in that training here, who hadn't graduated from a UK medical school, that at the end of their training they would need to apply for a work permit. But at paragraph 10 you'll see that this didn't apply to anyone who's already in the training system. This was prospective only in that regard. And it also concerned legislative change fundamentally, the immigration rules being considered to be equivalent to legislation. There's some debate about that, which is discussed actually in the case itself, but I don't think we need to trouble ourselves with it. There is reference to the Baker decision at paragraph 23, page 86, and the categories that Lord Justice Simon Brown identified in that case. And then in paragraph 24, you'll see that there was an attempt by Mr. Singh, as he then was, to bring the circumstances of that case into the category 2 example established by Lord Justice Simon Brown, which is our category, which is the circumstances where there's no prior practice nor a promise to consult, but the contention is there was an interest to be protected. However, when one looks at how this case then developed, we see this after an obligation of fairness heading at paragraph 41, beginning at page 92. The question to be decided is, in the absence of either an implicit bar on consultation or an established practice of consultation, fairness called for consultation with BAPAO or with those it represents in the rule changes. He acknowledges at paragraph 52 that they would have an adverse impact on those groups. Then goes on to say the real obstacle, which I think stands in the appellant's way, is the difficulty propounding a principle which reconciles fairness to an adversely affected class with the principles of public administration that are also part of the common law. Goes on to explain why that's so. And then at the end of paragraph 43, we see what's being contemplated by Lord Justice Sedley. It is not unthinkable that the common law could recognise a general duty of consultation in relation to proposed measures which are going to adversely affect an identifiable interest group or sector of society.
Yes, I'm just looking at the clock. I think it was an hour and a quarter.
Yes.
Mr. Burton, I think we've got a point about the distinction here.
Most grateful. And just to, then I won't read it, but paragraph 47 is where you see the ratio of the decision, which is on the facts, which is about statutory rules or quasi-statutory rules. So I'll move on from there.
But the distinction is, well, it's 45 onward, isn't it?
Yes, essentially it's the difference between saying a general duty in relation to anybody affected by a change in policy, which doesn't in any way take away from the second category identified by Lord Justice Simon Brown and Baker, which is about a very different scenario, albeit one that he didn't necessarily set out a very clear principle to distinguish other than by basing your cases on analogy and the facts. We see at 47 that there is no factual basis to draw that analogy here. But that's as far as that goes. But BAPAO is relied on by my learned friend, so I could not take you to why we say it doesn't apply here, or at least it's dealing with something else. Bat Murphy is the next case, which is behind tab 5, page 99.
Yeah.
Now, Bat Murphy, again, is a case where you're dealing with national policy, paragraphs 1 to 3. I'm not going to detail that for you at the moment, but it's basically changes to the schemes that were operated nationally on providing compensation to victims of miscarriages of justice, moving from a discretionary scheme to a statutory scheme, and a related change to the terms of remuneration for solicitors acting for people in that category. Paragraphs 18 to 20, just really for your pen at this stage, transitional provisions in place, which basically meant anybody currently applying for compensation under the discretionary scheme was unaffected, and indeed, by and large, those who are currently doing work on behalf of people who are applying for compensation under that scheme would continue to be paid under the old, more generous system. The legal principles are then discussed at length by Lord Justice Laws from paragraph 26 onwards. I'm just going to highlight a couple of key points, if I may, going through this. My lady, this is where you'll see some attempt to distinguish between substantive and procedural legitimate expectation. But paragraph 28, you'll see that there Lord Justice Laws links that to unfairness and abuse of process. It says abuse of power and unfairness go hand in hand, but identifying when you're in a situation where there's been a breach of the principle of fairness is always very fact specific. Paragraph 29, Lord Justice Laws deals with what he calls the paradigm case of procedural legitimate expectation, which was Lord Justice Simon Brown's category 4, promise of consultation. Then paragraph 32, substantive legitimate expectation, which is again building on Lord Justice Simon Brown's category 1, akin to estoppel. There's a promise, ex parte Coughlin being the best example of a substantive benefit. And then at paragraph 37, Lord Justice Laws starts to deal with procedural legitimate expectation, and Lord Justice Brown's second category. And then at paragraph 40, we see the issues that Lord Justice Laws considered to still be live, which is basically how do you identify or distinguish a case of either substantive or procedural legitimate expectation from, as it were, the ordinary course of events where policy is changed, and where the only expectation really could be that one will enjoy the benefit for so long as the public authority provides it. What is the difference? And Lord Justice Laws starts to discuss that in paragraph 41. And it's right to say that he says, well, both of these scenarios, whether it's substantive legitimate expectation based on a promise or procedural expectation based on the protected interest Simon Brown category 2, will be exceptional situations because their vindication is a long way distant from the archetype of public decision making for all the obvious reasons that we know. But at paragraph 42, but the court will, subject to the overriding public interest, insist on such a requirement and enforce such an obligation where the decision maker's proposed action would otherwise be so unfair as to amount to an abuse of power by reason of the way in which it had earlier conducted itself. In the paradigm case, it will generally be unfair. Well, I don't need to read that for you. So from paragraph 43 onwards, we start to see how Lord Justice Laws sought to try and draw that distinction, what principle would be applied. And he deals with substantive expectation first. And at paragraph 46, based on Coughlin, Lord Justice Laws says these cases illustrate the pressing and focused nature of the kind of assurance required if a substantive legitimate expectation is to be upheld and enforced. So this is the introduction of that language of pressing and focused, the language that was cited to the judge below, and in my submission, the language that helps explain why cases like Baker and indeed LH fall the right side of that line. And we see under the secondary case of procedural expectation, the learned judge or justice laws do the same.
So can we, he cites various cases, and can we skip to the bottom, with an eye to the clock, Mr. Burton, to the paragraph beginning accordingly, or the sub-paragraph, that's part of paragraph 49.
Indeed.
That is the key paragraph, is it?
It is indeed.
Or the key passage.
And that's the exact paragraph we say the learned judge effectively applied in our case. And again, building on by way of analogy with ex parte Baker. And then the final case is LH, which is at tab 8, page 188. I'll take this swiftly because LH is indeed the case that my learned friend says shouldn't be followed. But if one looks at it, one sees it's just a classic application of common law incrementalism by way of analogy with the Baker case. And of course, Baker, we know, has been approved at the highest level, including in Bat Murphy, one would say. Although that's not approving, of course, it's Court of Appeal, but it's not saying anything different from the decision in Baker. All the cases we've looked at were cited to the court in LH. You can see in the introduction at page 191 that similar to Baker, there'd been a wider proposal of reform to, in this case, daycare centres, not residential care homes. There'd in fact been consultation about all of that with affected persons. The issue was whether or not there needed to be subsequent consultation about individual closures of daycare centres in accordance with the principle of legitimate expectation and procedural fairness. And at paragraph 3, you'll just see the key factual issue being there that LH had been attending her particular daycare centre for 4 days a week and then subsequently 2 days a week, paragraph 3. You'll see at paragraphs 8 and 9 that there was this widespread consultation on the proposals and principle, but not the individual daycare centres that were going to be closed. And then from paragraphs 19 and onwards, you see the submissions that were made before the learned judge. And then at paragraph 21, Lord Justice Longmore then deals with that law as it applies to the case before him. And I take you to 21 because this is the part where my learned friend says Lord Justice Longmore got the law wrong, where it said, in the absence of any express or implied statutory duty to consult, the obligation to consult stems from the expectation that a public body, such as a local authority, making decisions affecting the public will act fairly. And it's this next passage. It says, if therefore a local authority withdraws a benefit previously afforded to the public, it will usually be under an obligation to consult with the beneficiaries of that service before withdrawing it. And it's that, usually, that my learned friend says is doing too much work, and contrasts with the language in Bat Murphy of exceptional. But the particular point there is, I mean, it's a good one if looked at on its face, but exceptionality in my submission in the Bat Murphy case is when Lord Justice Laws is looking at the grand picture of policy across the whole piece and saying it cannot be right that everybody who's likely to be affected by policy, even if they had some prior enjoyment or interest in it, should be consulted. One has to look for some principle to distinguish those cases where the duty of procedural fairness and legitimate expectation will recognise a duty to consult, and he falls on the pressing and focus.
Yes, that's the trigger, you say, that or the hurdle which takes the case into the degree of exceptionality.
Indeed, and for current purposes, all I'm going to say at this stage is then what Lord Justice Longmore then does, from paragraphs 22 onwards, all the way down to 28, is analyse in detail ex parte Baker and apply it to the facts of the case before him. And at paragraph 26 in particular, that's where the analogy is drawn between daycare centres and residential care homes. says, although closure of a residential home is clearly more serious than closure of a day centre, and although it can be said that the closure of Hartleys does not amount to an outright withdrawal of a service because the council will discuss with the users alternative courses of action which are available within the personalised budget, closure of day centres is undoubtedly a serious step to take from the perspective of their users and those who care for them. For the carers, the day centre will always afford a welcome respite. Even an ex-parte baker, there was not an outright withdrawal of the service since residents would be accommodated in other homes. In all the circumstances, I can see no satisfactory distinction between this case and that case. Essentially, what the judge below does is use that exact same analysis in the context of the centre we're concerned with, the Poverest Centre, as opposed to daycare centres, and explains in detail why they're analogous on the facts, having regard to the nature of the interest that the users of the Poverest Centre have. That's basically how the judge approached the question, and we say there was absolutely nothing wrong with that. So I said I would just headline our response to the submissions made by my learned friend in this appeal. I'm going to do this very quickly and give you the paragraph numbers because I've taken too long already, but hopefully we don't need to go to the cases again. The first is that there is a misdirection by not using the language in Plantagenet. We deal with that in our supplementary skeleton at paragraphs 9 and 10a to c. I'll see how my learned friend presents that argument.
Well, you can deal with that in reply. As appropriate.
You say it doesn't get there. Otherwise, we effectively are saying the points I've already foreshadowed, which is the judge was clearly applying common sense, analogous circumstances to the facts of this case, derived from LH and Baker, in circumstances which it's unimpeachable. My learned friend doesn't make a serious contention that that was a finding of fact not open to the judge. And that being the case, all the judge is doing is following the guidance in ex parte Baker, both literally in the sense of drawing an analogy, but also the guide as to how one adds to the cases in which the law will recognise a duty to consult based on legitimate expectation, even when there's no prior practice.
Yes.
So I won't say anything more about that at the moment. That gives you the shape of how we respond. Perhaps not in the most eloquent way, I appreciate that, but I had to get through those cases because I don't quite know how the arguments
I've got 5 minutes to deal with prejudice and delay. Or
prejudice,
5 minutes, prejudice and then serving.
Prejudice is
part of your 5 minutes?
I'm going to give her my 5 minutes on delay, yes. The arguments we make about prejudice are set out in the skeleton. Effectively, none of the cases we've looked at discuss prejudice. Insofar as prejudice is relevant, the judge makes it clear as day finding that there would be prejudice here. We've already looked at that.
Thank you.
And there's no serious contention that that wasn't available to the judge on the facts either. Of course, you have the overlap of the Section 31 principles, but we've made all the points yesterday we've made about how cautious the court must be about approaching the substantive merits in that way. So if I can then pass over to my...
Thank you very much.
On the question.
Yes, Mr. Irving. We might be persuaded to allow a little bit longer than 5 minutes.
That's very
after
generous.
you've been so unfairly treated by your learning leader. Yes.
If I could ask you to turn up the judgment at Core Bundle, page 91.
Yeah.
The learned judge deals with limitation from paragraph 65 to 69. In broad overview, the reasons he gives for granting an extension of time are as follows. He correctly identifies the date of the decision under challenge, which is the 22nd of January, and the date on which the claim was filed, 29th of July. He then considers that whole period of time and finds there was good explanation for any delay in issuing the claim.
Yeah.
He considers and rejects the defendant's submissions that granting an extension or relief would cause substantial hardship or detriment to good administration. And then he moves to exercise his discretion and grants an extension of time. And I will very, very briefly address each stage of the judge's reasoning to show he made no legal error. Now, the judge, in addressing the period of time between the grounds of claim first arising and the claim being filed, split that time into two distinct periods. The period from the decision until the claimant's family first found out about the decision, that was the letter of the 28th of April.
Yes.
And then the period following that, where they were taking reasonable steps to try to understand whether a final decision had been taken to close the Poverest Centre or not, prior to issuing the claim. So the first period, as I say, ran from the decision until the 28th of April letter, and the judge makes a clear factual finding at paragraph 69 that it wasn't realistic for the claimant to have known about the closure of the Poverest Centre prior to receipt of that letter. And I don't understand the respondent to be challenging that factual finding. Just for your note, there was clearly evidence on which he could make that factual finding. I would refer you to the witness statement of the appellant's father at paragraph 36. We're not going to turn that up.
So there is evidence upon which that finding is based.
I
Yes.
don't understand the respondent to be contesting that finding, so perhaps I'll just move on and we can deal with that in
Yes.
reply if need be. As to the relevance of this, the respondent concedes correctly in their skeleton arguments in this appeal that a claimant's lack of knowledge can be relevant to the extension of time. So far, so good in terms of the judge's analysis. As to the second period of time after the letter was received, the judge deals with this at paragraph 67 and 69. And he explains that the claimant's family, or the appellant's family, sought clarification from the respondent in May and June 2025 about what was going on, but the defendant was unclear about whether a final decision had been taken. There were references to a potential closure and a promise of a consultation. Given this, the judge concluded at paragraph 69 that the claimant had acted reasonably in seeking to resolve the matter with the defendant and to clarify whether a decision had been taken. And again, I don't understand that to be under challenge as factual finding, but if I might just give you a few references for your note to illustrate the confusion arising. In particular, supplementary bundle page 170. That was a letter that was sent out to families and learners on the 3rd of June, which repeatedly uses the language of proposed closure and promises a consultation. 172 of the supplementary bundle is an email of the 24th of June, again out to learners and their families. The subject line is proposed closure, the body refers to potential closure, and confusingly it refers to people already having received a notice of a 30-day consultation.
That's, yes.
On the same page above that, you see...
You say there's any significance in that mistake so far as this submission is concerned?
In terms of extension of time, we say it goes to the reasonableness of what comes to follow. In terms of whether there's a duty to consult, we say it's part of the broader picture, but we don't...
Yeah, no, I meant in terms, is this part of your case as to confusion?
Certainly,
Yeah.
yes. So what we see following that is the response from the appellant's father on the same page above, asking for the consultation documentation. So at this point, he thinks the consultation is happening on the potential closure of the centre. He's asking to be involved. Page 174, having received no substantive response, he sends a chaser. I've spoken to 3 other families, none have received the consultation documentation. We next hear from the local authority on the 15th of July, which is at 175. The subject matter of that email is still proposed closure. And this email informs learners and their families that the consultation will take place in the 26-27 financial year. 2 days after receipt of that letter, the first legal letter is sent on behalf of the appellant. That's at 179. And I would note that paragraph 24C of that letter expressly asks for clarification of the scope of the promised consultation. What are you consulting on? Are you consulting on the closure of the centre or just the future provision of services? A short response is received on the 18th of July, which does clarify the position. And so we get the formal pre-action response on the pre-action letter, on the 21st of July. And again, paragraph 58 asks expressly for clarification of whether a final decision has been taken to close the Poverest Centre or not, and for information on the scope of the consultation exercise proposed and promised. Pre-action response is received on the 28th of July and the claim is issued the next day. So on that basis, it was clear that the judge at first instance had an evidential basis to find that the claimant had acted reasonably in seeking to clarify the position, because indeed, if a final decision hadn't been taken to close the Poverest Centre and the promised consultation would address that question, there was no need to issue this claim at all. The respondent doesn't challenge that finding of fact, nor do they dispute that it is legally correct that in judicial review is a remedy of last resort a claimant who seeks to take reasonable steps of the sort shouldn't be penalised for a short delay in making a claim. Instead, as far as I can understand it, the respondent's complaint about the analysis of this period is in their skeleton at paragraphs 90 to 92. And it appears to be that the judge should not have considered events that occurred in May and June, because this was after the 3-month long stop provided for in CPR 54 had already expired. Now, this is a confusing submission because the judge was required to and did consider the whole period of time from when the grounds of claim first arose until the claim was lodged to determine if there was good reason for delay, and there was no error in him doing that. Finally, the judge considered whether there'd be substantial hardship or detriment to good administration if the claim proceeded and relief was granted, and concluded there was not. He summarised the respondent's submissions on this point in paragraph 65 of the judgment, and I pause to note that those are in fact exactly the same submissions that are being reiterated to this court in the respondent's skeleton at paragraph 94. He then made a clear factual finding at paragraph 68 that the respondent had failed to establish substantial hardship or detriment, and the reason for this was because the proposed housing development wasn't due to be completed until 2028. So in the context of that long time scale, there was no substantial hardship arising from the claim going ahead. Now, the respondent has identified no proper basis for disturbing that factual finding on appeal. And I would give you again just a couple of references in the documents, keep an eye on the time.
Yes.
The 28th of April letter, which is at page 162 of the supplementary bundle, confirms that all services will continue at the Poverest Centre unchanged until the end of the 26-27 academic year.
Was it 166, did you say?
162.
Sorry, thank you. Yes.
So no move from the centre is taking place, no changes to the services being provided at the centre were to take place until the end of the academic year that we're still in now.
Yes.
The other thing I would note, it is in Ms. Lee's witness statement, paragraph 67, which is at supplementary bundle 38. And that simply clarifies, my apologies, I'll let you know.
38?
Yes.
Yep.
Paragraph 67. So there, Ms. Lee is referring to an indicative timetable for the programme of works, which you find in the March 2025 report to the executive, and she's correcting an error in that report. That report suggested the main construction works would begin in June or July 2026, and she said no, the main construction works won't begin until summer 2026.
Summer next year.
Yes, that's correct. And given those long timescales, it was plainly open to the judge to find that the claim being permitted to proceed wouldn't cause prejudice. There was no clear explanation anywhere in the evidence as to how that would impact funding applications, or would delay the provision of housing, or would extend the period that the centre had to be maintained, given that it was due to remain open anyway until the end of the 27 academic year. So drawing together those building blocks, the judge exercised his discretion and decided to extend time, and that was an exercise of discretion by a first instance judge as a matter of case management, and we say respectfully a court should be slow to interfere. There is no proper basis identified for the respondent for this court to interfere with that exercise of discretion today. As far as I can tell, the only submission to that end is at paragraph 93 of the respondent's skeleton, where my learned friend states that the judge appears to have failed to give any weight to the need to bring the claim within 3 months in the interests of good administration, but that's not correct. The judge was obviously aware the claim was outside the 3-month long stop period and squarely considered whether there was any detriment to good administration and rejected the submissions on the point. So unless I can assist you further, our submissions are that there are no legal errors in this reasoning and no reason to disturb the clear reasoning of the judge at first instance.
No, that's very clear, Ms. Irving. Thank you very much.
I'm grateful.
Yes, Mr. Begler.
Thank you, my lord. My lady. Can I start by making some opening observations in relation to the case, then to address some of the factual matters that we say are particularly pertinent to the decision-making of the authority, then to turn to the judge's judgment, and finally to our response in the skeleton argument dealing with the various issues that we have there identified. My Lord, I'm conscious, one, of time, and two, of what was said yesterday in relation to the court's ability to having read into the document. So I'll take it as lightly as I can.
Yes, well, I hope we've demonstrated that we are really on top of the facts, Mr. Beckham. But
my Lord, indeed.
Take what course you wish. Yes?
I'm grateful. So, my Lord, firstly, in terms of opening observations, it is important to stress, just as a general matter at the outset, the local authority's commitment to providing adult education services. Mr. Nera and Miss Dionesco have dealt with that commitment in some detail in their evidence, and you also have information about the scale of the provision made in adult education services overall. You can see that, for example, at page 49, paragraph 23. I'm just going to give the court references. I'm not suggesting they should be.
I don't think it's challenged. Your local authority
no, my Lord,
is properly committed to these services.
Indeed, but of course that informs the basis of the decision-making process, as I shall shortly go on to say. And so the council's evidence is that the steps resolved to be taken in this portfolio restructuring significantly improve the council's position and that of the clients of the Adult Education Services Department. And that happens by a number of features which are recognised in the reports. Firstly, by the rationalisation of the estate. As the court has seen, it was a large portfolio of buildings that Bromley had access to and needed to make decisions about. Secondly, there was the prospect of the much more efficient use of spoke buildings. Thirdly, the prospect of substantial improvements to the hub building at the Kentwood Centre. And fourthly, improvements to the spoke buildings as well, so that they could host in a better way adult education services. And those improvements are what allowed the council to conclude that overall the changes proposed would bring benefits in accordance with the public sector equality duty. And the judge noted that that was our assessment, and he agreed with that as our assessment. And those two references are Core Bundle 85, paragraph 35 of the judgment, and in the judge's conclusion, Core Bundle, page 91, judgment, paragraph 63. Now, turning to the start of my learned friend's submissions yesterday, two themes emerged which were relevant both to section 31 and to issues in relation to consultation more generally. The first of those was an analysis of what I'm going to call the specialist courses point that are presently being provided at the Poverest Centre.
Sorry to interrupt, Mr. Beglan. You gave two references, paragraph 35 and 91 to the judgment?
63, my lord.
All right, sorry, I misnoted it. Thank you very much.
And the second point that my learned friend developed early in his submissions yesterday, and there was some discussion between the bench and my learned friend, was the idea that what might happen at the Poverest Centre was not a binary analysis, that there were the prospect, as I think my learned friend expresses it in writing, as being a myriad of options.
The 9 options were
in the options appraisal.
Yeah, that was, I understood it, that's a sort of source of his, well, not non-binary, slightly confusing phrase to use, but
yeah,
we know what we mean.
And in relation to the timing of that, of course, my lord will have seen and recall that that was in February 2024, yes. Relatively early. Yes. In the overall process. And so what we know is now happening, what has in fact occurred, is that there is a planning application before the authority for 44 units of affordable housing. Now, just pausing there to deal with a peripheral point that Mr. Burton made, he made the point that there are different kinds of affordable housing. Of course, that's right. But the affordable housing that is being proposed here is within what national planning guidance calls affordable housing within the MPPF. And there's no doubt about And what has happened as a result of the land take for that planning application for 44 units is that there's no question of there being a mixed use of that land. There's no question of there being a residual Poverest Centre operating from that land. So where I say ultimately both of these points that my learned friend was developing yesterday end up is that they are forensically interesting points in terms of analysis, but what they don't do is undermine the fundamental reality of the approach that the judge brought to the case, and in particular to the application of section 31(2)(a). As the judge was not obliged to address approaches that were ultimately not realistic ones in the prevailing circumstances, and neither was the authority. We submit that the specialist courses point has been elevated beyond the weight it can bear, and that is so because, and we'll see this when we look at the judgment and the other materials, it relates in truth to the provision of gardening courses for people with learning disabilities or difficulties, or SEND, those who want to pursue arts and crafts under the SEND courses that require sinks. And those are points which the defendant's evidence has identified, and so does the judge. And if we can just turn up at the core bundle at page 79, paragraph 7. We can see in paragraphs 6 and 7 what the judge is doing is setting out his understanding about the service delivery for LLDD individuals and making the distinction between the general run of courses that could be made available and those delivered at the Poverest Centre in Orpington in standard classrooms, but others.
Could you just give me that reference again? Sorry.
Yes, sorry. Core bundle 79,
Yes, thank you.
6 and 7 in the judgment.
I'm so sorry. Thank you.
So here we see that the judge early on analysing the nature of the service that's provided and then how it's provided. And in paragraph 7, range of courses delivered at the Poverest Centre, some in standard classrooms, but others with kitchens, outdoor areas, or in a large rehearsal room. So that is the distinction that's being drawn between courses that require specialist facilities and those that can be dealt with within a normal classroom. Now, another point that my learned friend made early yesterday and that he relied upon goes back to the idea about a myriad of options, is that during the discussion of how the estate might be rationalised, the Children's and Education Department were tasked to consider looking at their buildings and how many might be surplus to requirements. But when one looks at the way that exercise was undertaken, it was not a target to get to a third of buildings. It was at least in accordance with the rationalisation of the estate. And the reference for that is in Miss Lee's evidence, supplemental bundle, page 29, paragraph 30.
Right, should we turn that up?
So my Lord sees at the end of that paragraph reference to by at least 33%, and we can see that when we get to the reports themselves, what they were looking at was whether or not things were surplus to requirements rather than a specific target.
Yes. Could you just tell me, forgive me, where do we find the legible version of page 81? I've lost my note. 81 is the completely illegible for those of us with ancient eyes. Landscape document. Well, where was that? Where were the contents of that set up?
Yes. So unless one resorts to the electronic version, which isn't a PDF, so
I could do that.
So it can be blown up.
I'm sorry.
Yeah.
Hand it to me, Mr. Begleton. Where is it in a hard copy? You were told
A hard copy. My learned friend.
No, there was the contents of this were set out in a.
In the skeleton argument, yes. See the skeleton argument below.
That's right.
Yes, that's
Your
that's
skeleton
right.
argument.
No. In,
Appellants.
yes, in the appellant skeleton argument.
you.
But
Carry on. If you could just give me that reference.
what you won't find from recollection in that part of the skeleton argument are the numbers.
Okay. Well, would you be good if I?
My lord, want to have a look at the PDF version,
No problem.
page 81.
Carry on, Mr. Begleton. Don't wait for me.
The options do have numbers at page 125, core bundle.
Thank you.
Grateful.
Yeah.
But what you will
We were in Miss Lee's statement.
we were, just to make the point that the rationalisation of the estate was based on what was surplus to requirements, not that there was a target of simply reducing 6 buildings in the CEF department. Well, we can come back to the options appraisal because we need to do that.
Yeah, okay.
But the rationalisation of the estate, of course, as the court knows, was set against severe budget pressure. And again, just to give a reference for that, that's supplemental bundle, page 27, paragraph 23.
Sorry, can you give that again?
Yes, supplemental bundle, page 27, paragraph 23.
In the same statements.
Yes, indeed. And the overall approach was to remove surplus buildings with a view to not reducing services and with there being a priority perfectly properly given to statutory services rather than, as adult education services are described in the report, a non-statutory service. Now, the last point that was made yesterday that I want to deal with by way of introduction, the appellant suggests that the movement towards rationalising the estate proceeded on the notion that Kentwood Centre can take the courses, but without any particular reference being made to the courses that were being undertaken by LLDD clients. We suggest that that is wrong, that in fact there was an awareness of that feature and it was being taken into account from the beginning. And again, if we look at the core bundle, supplemental bundle, page 49, paragraphs 20 and 22 of Ms. Diaconescu's statement, what we can see there is the early feasibility work specifically considered how to meet the needs of those 2 groups. And then paragraph 22, a paragraph that my learned friend relied on yesterday. We know that the equality impact assessment also addresses those questions. And to give 1/3 reference, if we look at page 59 of the supplemental bundle,
Sorry, can we, you just, for my note, I'm not
Yes.
getting this, so, and it's important for this. So in Dernesco, which bit I couldn't, you just gave paragraph numbers and I couldn't actually read which bits you want me to pick up.
sorry, my lord, it's paragraphs 20 and 22. If we turn back to those, what my lord can see, it's the whole of paragraph 20, which shows that feasibility work, this is lines 3.
Yeah, I can read that.
Yes.
And that's redesigning the spaces at Kentwood. So
Yes.
how does that help us? because I'm sorry, I only had time to read that quickly. I got to the first 4 lines, then you went on. But how does that show what you're trying to make it show?
What that shows is that from the very earliest parts of the analysis, professional input was being provided, which was dealing with how plans should specifically meet the needs of learners who were SEND learners and who had learning difficulties or disabilities.
Yeah.
So it's an unsurprising point, but it was always there in the background and integrated into the approach that the authority took. As I say, the equality impact assessment also addresses that. And then if we move to page 59,
Thank you.
and paragraph 51, we can see again when the issue of course changes was being addressed in the response that we gave to the claimant's concerns, and that response started some pages earlier in the witness statement. Key improvements factored into the overall adult SEND provision, including those that were identified there. So again, it's just to make the point that this was a feature that was always there and integrated into the local authority's thinking and approach. And because gardening is one of those areas where specialised provision was potentially required, you can see that there were other areas in which the authority had considered that. And again, I'm not necessarily inviting my lord to turn them up now, but in relation to the West Wickham Library garden and facilities, for example, you can see that, Miss Lee discussing that, supplemental bundle, page 39, paragraph 71, and earlier discussion of outdoor areas in paragraph 68. And indeed, the extent to which in the large portfolio of sites there was other land available in the spokes that could be put to horticultural use. That was something that was discussed before the judge, and a number of other areas were identified to him just as potential areas where that activity could take place. But this point about whether or not the Kentwood Centre taking the courses without there being analysis of the LLDD position is also directly addressed in the key January 2025 report. And we can see that in the supplemental bundle at page 120. Paragraph 3.21. And 3.21 and 3.22 are key paragraphs that the court will have read before. So just to take some of the main points from 3.21. Poverest is surplus. 5 lines down, the cost of repairing the Poverest site cannot be justified in the current financial context. So that was a finding of the authority that informed its approach. And therefore, a new approach to delivering adult education is required, and it speaks to consolidation and the spoke model. Carries on, there will be changes to how the adult education service is delivered, and therefore a number of programmes will move to be delivered from alternative locations. Therefore, this will have an impact on some service users, as reflected in the equality impact assessment. Every effort will be made to mitigate the impact on service users, particularly those with protected characteristics. So again, that is being recognised throughout the analysis and something that informed the plans that the local authority took forward. And just while we're here at 3.22, you can see that part of the operational planning in relation to the Kentwood site was an aim to secure a higher grant, it's the last 3 lines, for a more comprehensive catering kitchen to be installed, which will enable more students to do more intensive catering courses delivered from the Kentwood site. So again, one example of the improvements to the service overall that would be facilitated by the rationalisation. And so any suggestion that those weren't features of the analysis from an early stage would, in our submission, be wrong. The next point to deal with returns to the point about myriad alternatives. And here one needs to be careful, we suggest, about a conjecture that Poverest Centre could be used for some form of mixed-use scheme and still continue to provide for cooking and horticulture. Now, there are a number of difficulties with that. One of them is that when we look at the work on the options appraisal, when one blows up the page so it can be read, what my lord would see is that in fact the way that the housing was proposed in this desktop analysis to be provided on the site was by using the available land, and then the building would remain. But of course, if you use that available land, you no longer have land that you can use for horticulture, as a straightforward point. Secondly,
land you can't use for horticulture.
Yes, because it would be built form development. That's where the housing would go on those options within the options appraisal. Yeah. You can't have your cake and eat it in that respect. Next.
Sorry, is this case all about gardening, or is it about kitchens and all sorts of?
No, it's not all about gardening, but it's essentially about 3 things, and this is the way that the judge analysed it in his judgment, as we'll come to. It was about the provision of gardening, which was said to require a specific resource, the provision of cooking, catering courses, which were said to require a specific resource, obviously do, and lastly, in relation to some arts and crafts that needed sinks. And that was, as the judge analysed it, the extent of the special provision that might need to be required, and ultimately about which consultation, so the judge said, needed to take place. And so it's important when one's analysing whether or not there was a duty to consult, to look at what the judge ultimately arrived at in terms of what that consultation would be servicing, what it would be directed towards.
Could you just flag up for my benefit those passages in the judgment you're referring to?
Yes.
So just so that we have it in mind that these 3 things were the key things, as you say.
Well, if we pick up the judgment, or bundle it, starting at 78, got the 2 paragraphs that we looked at, 6 and 7 on page 79. Then the judge deals with the provision of specialist facilities in paragraph 18. Sorry, while we're doing this exercise, it's worth looking at 13 as well, where he's analysing the authorities material. Last sentence there, the review noted that Poverest was not a specialist building and many of its courses could be delivered elsewhere. And then we get to paragraph 18, May 2024, when the 19 sites are being considered. Poverest was not identified as crucial or specialist location which needed to be retained, as the defendant decided that many courses could be delivered effectively from other available buildings, while courses requiring specialist facilities could be delivered at Kentwood. Then if we move down to 22, he's looking at the spatial planning questionnaire, later on in 2024. Need for accessible provision at Kentwood, cookery room.
I'm just noticing the words such as.
Yes. Well, my lord, that's right, but overall, what the analysis is directed towards are those activities that can't be carried on in a classroom. And those are the three main activities. So the authority decided on its evidence that there were cooking courses that needed to be catered for, some art and craft, and some horticulture. Everything else, the authority's case, is that the substance of all of the other provision can be made within a typical classroom setting. So if you have, for example, digital learning, that can be done by reference to computers that can be moved, iPads and things of that nature. If you're dealing with language introduction, if you're dealing with mathematics, all of those kinds of courses that are fundamentals of the way.
That might be the way that the local authority looked at it, and I can see all of that, but that doesn't really meet the claimant's case, does it? Because the claimant's case wasn't just, I need to have some specialist services somewhere in the borough. It was, Poverest serves me because I can get to Poverest, so the location's important and my community's important and all the other things. And as I'm just having a quick look at the judgment, it sounds like the judge decided that it was the whole lot that should have been consulted on. It wasn't just whether there were going to be gardening services or kitchens somewhere else. Paragraphs 54 and 55 are the fairness of taking account of everything that this claimant wanted to say, not just about the nuts and bolts of what was going to be provided, but the sort of where they were going to be provided, and the reasonableness of provision at Poverest.
Yes.
All those other reasons too.
My lady, no, we say not. When you look at paragraph 52 of the judgment, the judge refers to the identifiable cohort, and at this stage he appears to be speaking to both users of Poverest and those with special needs. So it's not just, as it were, the 100 or so LLDD community there, but those who have used Poverest, and in particular, those who are long-term users. That's the phrase that he uses at paragraph 54. So what the judge appears to have in mind is a consultation that would be directed towards long-term users of the Poverest Centre, whether or not they also happened to have LLDD. And then we see at the end of paragraph 54, the fact that some courses would be provided elsewhere does not remove their legitimate expectation that the specialist Poverest Centre courses will continue to be reasonably available to them. So it's the specialist courses that the judge had in mind in that respect. And these were conclusions that the judge formed, having taken on board the respondent's evidence on those matters, having not disagreed with that evidence. And the substance of that evidence was that most of the courses could be dealt with within a traditional classroom setting. And so that's why the judge, paragraph 55, when he's analysing what fairness required in the circumstances, was the ability for there to be commentary on the specialist courses, as my lady indicates, in the south of the borough. And so that's the nature of the consultation that the judge had in mind, rather than on those broader issues.
Yeah, but okay, well look, there we are. As I read it, it's the idea of not just the specialist courses, but where they were going to be, because the accessibility depended on location.
Yes.
So it was the whole, it wasn't just, have I got a kitchen, if it's going to not be anymore at Poverest, can I find one at Kentwood? That wasn't really the point.
The specialist nature of the services was the focus, but I accept the point my lady's making, that location was important, and that's why, amongst other things, the Equality Impact Assessment looked at that issue about location and how other alternatives in the spokes might be provided. But those are the reasons why we say that when the judge looked at this issue of consultation, what he appears to have fastened on is, and one can understand why, bearing in mind what we say that the law about consultation is, that you shouldn't easily impose a duty in these circumstances, that it needs to have a level of precision and specificity to it.
Wasn't there more to the provision of education than simply the nuts and bolts of the specific courses? It's also the more intangible aspect of going to the establishment, meeting the social care assessment, in the claimant's case, of developing or maintaining personal relationships.
Yes,
like
but
all schools.
But if one, as it were, the benefit of the judge's formulation is that it does have, or moves towards that level of specificity that the authorities do say is important when we look at Bappio and Westminster, for example. If one starts to move away from that towards a much more general consultative exercise, then what is the basis upon which it's being imposed? Is it being imposed in relation to users that have been using the site for a short period of time? The judge didn't seem to think that they should fall within the consultation obligation. Is it being imposed on those who might use the services next year? Is it being imposed in relation to other individuals who use the service more generally? And it's when one gets to those kinds of areas, first of all, the consultation would lack the specificity that we suggest the common law requires it to have. And secondly, in terms of a strategic reorganisation, what input would that provide on those levels of broader strategy that the authority would require from a consultation?
Is it envisaged that the specific courses that you've been focusing on, and you say the judge highlighted, will all be provided at the Kingwood Centre?
No.
Kentwood Centre?
No. They will. They will
Some
all
will be provided there.
capable of being provided at the Kentwood Centre, but there are a number of other spokes, and this is part of the point, that have access to, for example, garden land, that have access to sinks, that have access to other provision that relates to the ability to carry out these courses.
Is it therefore a factor that the judge will need to consider that although the various requirements of various courses can be provided under the new scheme, they can't all be provided in the same place? For this claimant.
But they could all be provided in the Kentwood Centre. This claimant is indicated in the evidence difficulties with accessing that centre, but what there are other spokes that are near Poverest, and we can see that on the map that your attention was.
So yes, that's my point. They could be provided. If you can't go to Kentwood, they're available.
Yes.
But they're available in different locations.
Indeed. And that's the point of the spoke model, to increase accessibility and to increase reach overall. And that is the finding of the authority, what it will do. And that was the finding of the judge in relation to his acceptance of the equality impact assessment that I drew attention to earlier. So that's why I say that this is not, on proper analysis, a case about removal of services. It's a case about reconfiguration of services, where in fact the conclusion of the authority overall, and this is what's reflected in the equality impact assessment, was that there would be improvements.
This is a case about whether this claimant should have been consulted before you made your mind up. That's what this case is about, isn't it?
Yes.
And I don't, that you make some very good points. We can read what's on the paper and so on, but I suppose the case boils down to whether he might have had some things to say that you ought to have listened to before reaching conclusions. I mean, that's what this case is about, isn't it?
It's about whether or not we were obliged to listen to him before making the strategic decision. And there are a number of things that go towards what we say a duty to consult might have arisen to deal with. But before I get to that, can I take the court briefly through the reports to show?
Yes. I'm just making it of where we've got in your submissions. We interrupted you, Lady.
Yes,
a little bit. I don't want to take you off course. So,
my lord, I'm grateful for that. I was making some opening.
We're still in our opening observations.
Yes, but I'm going to move to deal with the documents.
Right.
But
okay.
Just before I get there, we were dealing with the prospect of mixed-use schemes, and part of my overarching submission is that the judge wasn't required to deal, and this court isn't required to deal, and the authority wasn't required to deal with what may be unrealistic conjectures about what this scheme could have produced. And that is relevant when we get to the Section 31. And in relation to that, there is also the point that this court, we say, needs to consider whether or not, if there was not consultation at the strategic stage, whether or not that led to conspicuous unfairness as being an important part of the test. And so it boils down to whether or not there was conspicuous unfairness in deciding not to consult on the strategic issue of disposal, and instead, because this is what the authority decided to do, to consult on the operational plans in a way that would substantially mitigate impacts, because that was the authority's finding. You know, no one has upset that to say that the authority had properly concluded that the operational planning would allow for substantial mitigation of the impacts. And so, if we turn then to the facts, an important part of the factual matrix to bear in mind, if we turn to the supplemental bundle, page 98, we can see, just reminding ourselves where we are, page 97, this is the November 24 spatial planning responses that were given in relation to questions from the architects. And one of the things that the court will have picked up here, but it's worth just marking where it is, are the differences in level of provision between the Poverest accommodation and the extensive Kentwood accommodation as described there. And then as we go over the page, the point that I want to draw out from this document relates to the overall proportion of SEND learners within the AES services. And we can see, if we total those figures of anticipated learner numbers by curriculum areas, you would get to a total of 3,470, including the 120 SEND learners. And what that means is, in terms of the overall cohort, they are in the order of 3.5% of the total. Now, that's an important point of context in terms of the overall rationalisation of this service.
Can I just ask you, do you draw a distinction between SEND and LLDD?
My lord, there are distinctions to be drawn. They may not matter for the purposes of this case, but just to take examples in relation to special educational needs, that could include, for example, someone who has dyslexia. It could include someone with autistic spectrum disorder, but with
a broader category.
Yes. The learning difficulties and disabilities normally needs more specific intervention.
Yeah.
And so, because it's quite rightly accepted by my learned friend that there was a systematic decision-making process within the council, we know it was looking to find surplus properties and rationalise those. Reference to that is supplemental bundle, page 23, paragraph 6, Miss Lee's witness statement. And more specifically, if we turn and briefly make our way through the documents from November 22, the report of 30th of November 22 starts at page 5 of the supplemental bundle.
Page 5.
Sorry,
That's in the middle. Right.
bad reference. Grateful to my letter friend. Page 69.
Yes.
And if we look there,
Yeah.
we can see what's happening. It's the reason for the report is to try and create the optimal operational estate, to understand the liability over a 10-year period. And so that's what's being discussed through the report. We can see at 3.3 the need to reduce liability to a financially sustainable level. So that's the aim. 3.5 refers to the schedule of properties that were under discussion, and we've seen in the evidence that there were a very large number of properties in that respect. And then if we move on to look at the strategic decision making that was being done in the report, we can move forward to paragraph 3.25 on page 74, just to look quickly at what the strategic objectives were. Firstly, to rationalise the estate. Secondly, to target investment. And then thirdly, to release property assets not required. So that was the threshold test, whether or not they were required, in order to generate capital receipts and then release sites for delivery of affordable housing. So those were the two main purposes that were under consideration here. A third was the potential of transferring assets into community ownership, where community is best placed to manage it, but that doesn't arise in our case. So it's really those two approaches that were the strategic objectives. And then if we move forward to 3.43 on page 77, we can see that at this stage, so relatively early on in the process, Workstream 5, sites potentially to be developed for council housing, includes Poverest Adult Education Centre at the foot of page 77. Subject to feasibility and business cases, they were done. And then the court will have seen, just looking at the overall decision-making process that took place, that there was provision for scrutiny committees to look at what the authority was doing and potentially to challenge the decision-making process. That's done by way of cross-party composition of committees. And the reason that's important is to go to support the cases, our ability to rely on cases like L, where what was being discussed were changes to budgetary provision that would have effects on services, and there being an appropriate level of deference and respect for the democratic decision-making processes. And just in broad terms, one can contrast that between circumstances, take opposite ends of the spectrum, where, for example, there's a planning officer, single professional dealing with an individual planning application, compared to a strategic reallocation or rationalisation like this, where there are different levels of the authority involved over an extended period of time in thoroughly considering what the options are and reaching conclusions with the benefit of the scrutiny committees and with matters going to the executive, so that there is direct member involvement and it's therefore part of the democratic decision-making machinery rather than simply something that is dealt with at officer level.
Can you just give us a reference to the scrutiny committee?
My Lord, yes. page 83 of core bundle, supplemental bundle, I think.
Yeah.
And where on 83?
Sorry, my lord, that's a bad reference as well. But okay, can I come back to that point when I've got a reference? But the scrutiny committee looked at the materials before they went to the executive for decision in January 2025. So, having looked at what was happening at that early point in time, we turn to the options appraisal. If my lord has access to that. Page 81.
Yes.
And if, for these purposes, my lord does enhance the magnification on that page, what my lord will see in relation to the 9 options that were available is large negative figures in the millions, apart from in relation to option 6, which was disposal. That comes in at 0.35 millions, a fraction of the various other amounts. And that was for disposal. And so what that meant is that this wasn't a close run thing in terms of the potential other options. Disposal, in accordance with the strategic objectives that we've just looked at, was the way forward for this project, subject only to whether or not it turned out to be one of the few sites that could be brought forward for affordable housing. And we know that ultimately that is what happened. It was one of the 2 sites that was identified in the March 2025 report in relation to affordable housing. But the point that arises from that, and in terms of how this land would be dealt with, this will go to the section 31 point, is that there are essentially 2 options applying the strategic objectives of the council. The first, and the one that is very clear on the mathematics, and the reason the mathematics are important is because that's not the kind of issue that one necessarily needs a consultation response on, because it's simply that matter of arithmetic. And we can see there how powerful the case was in relation to potential disposal of the Poverest Centre. So that's the first thing that might happen. The second thing that might happen, applying the strategic objectives of the council, is development for affordable housing.
Yes.
And so if one just theorises for a second about the nature of the case that would need to be made in any consultation response, it would be to displace both of the council's overarching strategic objectives in dealing with the rationalisation of its estate.
Displace the options, did you say?
Yes, it would have to be of such a convincing nature that both of those options, which have been identified as the strategic priorities of the council.
Both of the options, yes.
So disposal is first.
Yeah.
And we've just seen on the pure arithmetic how powerful the case for disposal is. And the only thing on the strategic objectives of the council, because it wants to realise money from an overlarge estate so that it can rationalise its services and continue to provide those services because it's able to raise money. That's the tenor of the council's evidence. So the only way that you get from a position where there won't be disposal is if something can come forward for affordable housing, because that is an even more precious resource in the council's analysis, because it's, as the court will know.
You've got 2 options that are that, 3 and 4. Say as I read it, keep Poverest, but use some of the spare land. Well, keep the services at the Poverest Centre. One option is keep the centre as it is, I think, and put some housing around the edge. And the other one is bulldoze the centre, but put some housing up as well as. And they're expensive options, as you'd expect.
Yes.
But that's, I mean, it's not because of it, it's just that that's involved building houses as well. So that does meet the strategic objectives, but it's a completely different way of looking at this particular site.
Yes, and what becomes clear from what happened after the options appraisal in February 2024, which is of course a snapshot in time, is that, and it's a standalone analysis. I mean that's our evidence about that. You can see that being discussed in the supplemental bundle, page 27, paragraph 7 of Miss Lee's witness evidence.
Page 27, paragraph what?
Paragraph 7.
Thank you.
Thank you.
Paragraph 7.
Should be paragraph 7.
On page 27.
Page 23.
Sorry, it is the right page, page 27, but it's the wrong paragraph reference. It's 24. So if my lady looks, paragraph 24, fourth line, producing an options appraisal as a standalone piece of work. So it's analysing the position at a point in time as a standalone piece of work. And then what happens after that are a series of meetings and consideration by the council. Does my lady have that paragraph?
No, I'm looking for something saying standalone. Where's that?
Line 4.
Of which paragraph now?
Paragraph 24 on page 27. Supplemental bundle. So it's a standalone piece of work at that time, and then there are a series of meetings that are described in the evidence where the picture in relation to the Poverest Centre is taken forward, and the evidence is that the consideration is that it should come forward either for disposal or as affordable housing, and there is no suggestion in any of that evidence that there was really a viable way of coming up with a mixed-use scheme that contained affordable housing. And that chimes with what's happening at the moment in terms of the full planning application that's coming forward for the 44 units. And so whilst one can theorise about the prospect of a mixed use on that site, that's why I say when you look at what has happened since then, what that shows is that there is an unrealistic suggestion, perhaps still remaining, that some form of mixed use development might come forward.
Can I ask a very boring question about the 44 units and where the evidence for that is on the appeal?
Yes.
As I understand it, that postdated the judgment.
It postdates the judgment.
So we're looking then, are we at a joint application to adduce fresh evidence or what?
My Lord, no, for this reason, that in one of the applications that was made to this court, the appellant referred to the fact that the application had been made, and that application contains the description of the development. It doesn't contain any more than that, but it does contain the description of the development as being a full planning application for 44 units.
Well, that may have been relevant to the issue of acceleration or early hearing, but if we're looking at an appeal, and sorry to be technical, but the court said often everyone needs to have some regard to the technicalities of this. It's not evidence that's admissible at the moment before us because no one's applied to adduce it. I mean, fine, they've referred to it in interim applications.
Well, my Lord, then I don't seek to take that any further, other than as an update to the court, so the court is aware. Can I, on that basis, move back to the supplemental bundle and to what was going on at the workshops in 2024? So if we move back to Miss Lee's evidence, that's pages 28 and following. Again, just to note, when the issue is one of whether or not there should have been a consultative exercise and what form it ought to have taken. Overall, this was looking at 53 operational properties across the piece. That included the 19 from paragraph 28 within the CEF portfolio. And we can see the nature of the discussion and involvement of senior officers. That's paragraph 29. And then if we move across to paragraph 34 on page 30, what we can see there is discussion about which buildings were thought about as being crucial. So a series of challenges, 3 challenges set out for the 10 senior officers to consider. And at the end of that paragraph...
Which paragraph are you on?
34, my lady.
30.
34.
On page 30.
Yes, on page 30. Last 3 lines on that paragraph, it's agreed that all other buildings were not specialist, with the services being able, in theory, to be deliverable from any building with little or no specialist setup. So that's an example of where the senior officers are pooling their expertise and deciding about the ability of this wide portfolio of properties to provide those various courses.
Without any contribution from the users. Is that right?
Well, my lord, yes, directly, because these are precisely the individuals, and you have the experience of the individuals who've provided witness statements, because they set that out at the start of their witness statements. That's the point of there being directors across the services meeting, so that all of these issues about transforming the estate, which land is most valuable, which performs a particular function as far as a service is concerned, that resource is all pooled by the officers, subject later on to consideration by scrutiny, and then put in front of the executive as part of the democratic process. My submission on that is that this was a very thorough process, and that the conclusions that the senior officers arrived at are ones that were certainly open to them to reach, and they furthered the strategic objectives that the council had in place. And there is no criticism, there couldn't be any criticism of those strategic objectives or the steps that the council was taking to meet them, bearing in mind the needs to raise money to continue to provide levels of service and the need for specific provision of affordable housing. And that was the conclusion of the officers. They went on to consider, and we can see this second challenge, relating to provision of affordable housing and whether or not sites could be sold. And this is an important point to note in terms of the prospect of there being myriad solutions. The officers again looked at whether Kentwood was a site that could be suitable for being sold, as we saw that Poverest potentially was, and there was a decision that it wasn't suitable for those purposes. So then when we get to how the judge approached this, and he relied on the evidence to say, look, that there had been determinations in relation to what Poverest should be put to in terms of a use and what Kentwood needs to be put to in terms of a use. He was right to come to those conclusions in informing his judgment under section 31. Paragraph 35 tells us about the conclusions that were reached in relation to Kentwood, And then in paragraphs 36, there's discussion of alternative sites, and 37 moves on to Poverest, and there's a detailed discussion about what could be done with the Poverest Centre. And at 38, the conclusion of the officers was that there was a huge potential for housing on this site. In fact, later on in that paragraph, it's described in terms of the tenor of the meeting as being the ideal site for housing development. And so that reflects the strength of feeling and opportunity in terms of how Poverest might be taken forward in the future. Just in terms of the continuation of the democratic process and senior officers being involved, the court will also have seen on page 32 the description of the chief officer executive meetings and what was happening there. Another way of checking that the conclusions that were being reached in relation to the rationalisation of the estate were secure. And then just moving forward in time to deal with the reporting from January 2025, we can see there, paragraph 55, Miss Lee's proof of evidence, page 35. The officer's judgment in terms of what could be achieved is that there could be reduction of the operational estate without significant impacts on services. And that's reflected in various of the documents, including the Equality Impact Assessment. And the reorganisation could be facilitated, this is 3 lines in from the bottom of paragraph 55, without material reductions in services. So that was the approach that the authorities' senior officers considered was open to them. That this approach overall could be achieved without material reduction in services. And in terms of where that appears directly in the report, if we just pick that up for a moment. Starting at page 112 of the supplemental bundle. And if we look at what was under discussion there in terms of the recommendations, we can see the progression for operational planning in 2.2 and then the disposal of sites unless officers identify affordable housing delivery potential for any of these sites, in which case separate reports will be brought to committee. So that's the hierarchy of strategic objectives that the council was following through on. And if we look at page 116, paragraph 3.5.
Sorry, page 116.
Yes, my lady. We can see there identified the role of the operational plans. And then within the context of the extended property review, just showing that this point about the rationalisation being able to be undertaken without significant impact on services was directly reported to the decision makers. That is in paragraph 3.6 of the report. So in terms of what the decision makers were being told on the basis of expert advice, that was there specifically before them. This rationalisation could occur without there being
Significant.
significant impacts. Yes.
Yeah.
So, as we know from paragraph 3.13 on page 119, so the court has it, the EIA was appended to this report again, so it could be seen by the decision makers. And then 3.21 across the page, the two paragraphs that we looked at that really were central at this point in time to understanding the approach to Poverest.
Yeah. 3.212. Yeah.
Yeah.
Yeah. Right. Have we got to a point?
Well, that's a perfectly
point?
convenient point.
We finished with that report. Thank you very much. How are we doing, Mr. Beglam, in terms of your timing?
My Lord, I will endeavour to be finished within, well, can we say by 3:15? Perhaps by 3 o'clock? 3 o'clock or...
Well, that will be very good if you can manage that, but I know you've got some ground to cover, so no doubt you will. Thank you very much. Look forward to seeing you all at 2 o'clock.
All right.